I'm Drew Stevenson, and this is a lecture about the case Lujan versus the Defenders of Wildlife, a U.S. Supreme Court case from 1992. And this is really for my administrative law class. And here we're going to be talking about standing to sue. And I want to say something just a moment for my students. This is one of the most important cases about standing. It's still heavily cited, and you may have covered it in constitutional law. In administrative law, we might be talking about it in a slightly different way, so it's worth taking another look at. Also, keep in mind that apart from this case and one or two others, administrative law casebooks have a wide variety of standing cases. We get a lot of these cases from the Supreme Court, and to be honest, the outcomes are often unpredictable and they often split on party lines. So let's look at what happens in this case. So our main takeaway here is that this, just to kind of frame the case, this is a wildlife conservation group, and they wanted to sue to basically block some U.S. foreign aid that was going towards overseas projects in other countries that would harm some endangered species there. And the question before the Supreme Court was whether these individuals should have standing to sue. And the answer was no. But let's unpack this and look at why. So we start with the statutes and why we're suing and who we're suing and how this works. This is a little bit complicated, but you might not have talked about this in constitutional law, but in administrative law, it's time to take a look at the statutes and the agencies involved. So the Endangered Species Act basically divides responsibilities for the protection of endangered species between two agencies, the Secretary of the Interior or Department of the Interior and the Secretary of Commerce. And other agencies, depending on which agency it is, have to consult with one or the other of those secretaries whenever they're going to take an action or do a project or even fund a project that someone else is doing. That's a type of agency decision, is giving money to for some sort of project or construction project. And they have to consult to make sure that the actions that are getting agency funds don't jeopardize any endangered species or threatened species or their habitats, right? Because if we wipe out the place where they live or where they mate or where they have to feed and so forth, then the species will go extinct. Now, initially, at one point, both of these secretaries, the Secretary of Interior and the Secretary of Commerce, had gotten together and promulgated a joint regulation that extended the Endangered Species Act to government activities or projects overseas that occur outside of the territorial United States. And later, they basically reversed that position and limited the geographic scope of the Endangered Species Act to the United States and the high seas. And basically, the upshot of this was that it would not cover projects in foreign countries that the federal government was funding. Now, at the time, the United States was overseeing and helping fund the rehabilitation project for the Aswan Dam in Egypt. This is a really large dam project, and the project itself would harm the habitat of the Nile crocodile. Whatever other advantages there were to repairing and updating the dam, it would definitely cause some environmental damage, and that is where the Nile crocodile lives, and the crocodile is an endangered species. And so one of the identified members of the Defenders of Wildlife group, that's what we're going to call this plaintiff number one, had previously visited their habitat. So this was somebody who is an expert in crocodiles, like a biologist, and they were hoping to go and see them again, even though they didn't have plane tickets or anything like that yet, or a definite plan, but they had been there before, and they planned at some point in the future to return. We had a similar situation going on in Sri Lanka. The United States was funding a development project in Sri Lanka that would have ended up endangering some of the natural habitat of the Sri Lankan elephant and leopard. So the second plaintiff was a member of the Defenders of Wildlife who had visited their habitat there in Sri Lanka in the past and had been hoping to return to Sri Lanka after the Civil War. At the time, there was a civil war going on there, so it wasn't safe to travel, but they were expecting that to resolve soon, and they hoped to go back and continue their studies of the elephants. Now, this brings us to Mr. Lujan. These wildlife conservation groups sued, seeking a declaratory judgment that this new regulation, and we're talking about this rule that narrowed the Endangered Species Act geographic scope, that was wrong. And they wanted an injunction that would have required the Secretary of the Interior, who was Manuel Lujan at the time, pictured here, to promulgate a new rule restoring his initial interpretation, which basically would have applied it overseas. And so he became the main named defendant in the case, even though he wasn't actually doing these projects or taking actions directly that affected these endangered species. It's more like a but-for causation, and I hope my administrative law students can see that. Now, as far as the holding goes, the court held that in order to have standing, the plaintiffs have the burden to show an injury, and this is kind of the first time they spelled it out quite like this, that the injury has to be concrete and particularized and actual or imminent. So it either needs to have, when we talk about actual or imminent, it needs to have already happened or be happening or be just about to happen. And when we say concrete and particularized, we mean something that's not conjectural or subjective, right? You could define it. You could put a dollar value on the cost or something like that. And particularized means that it affects this plaintiff in some special way, as opposed to just being a harm that affects everybody in the world, and you are suing as a member of the world or a resident of the world or something like that. They also have to show a causal connection between the defendant's actions and the harm, and that the injury will be redressed by a favorable decision. So if you lose on any of those points, you don't have standing. That's the point here. So you have to have an injury in fact, and that we define injury in fact as concrete, particularized, and either actual, already occurring, or just about to occur, imminent, not some far off time in the future, like 50 or 100 years from now. And you have to show causation, that what the defendant is doing is actually causing the harm in some way, and that if you win at trial, that it would actually make a difference. I pulled out a quote for those of you who like to highlight in your casebook or focus on a kind of something that shows the crux of the case. Their hopes, quote, to return to the places they had visited before, where they will presumably this time be deprived of the opportunity to observe animals of the endangered species, is simply not enough. In other words, they don't have standing. Such someday intentions, without any description of concrete plans, or indeed any specification of when the someday will be, do not support a finding of the actual or imminent injury that our cases require. In other words, the first point is we're losing on actual or imminent because they didn't have any definite plans for a scheduled trip. If they did, it might have made a difference. So there's also a question about redressability here, right? So even if the government-funded activities abroad threatened certain species, and they hadn't gone to trial, so they hadn't had an opportunity yet to prove that that was happening, but let's just assume it is, but it was unclear. The plaintiffs failed to show how this would directly affect any of their members apart from the members' special interest in the subject. So obviously, if you're a member of the Defenders of Wildlife, you like wildlife and don't want it to become extinct. But they wanted to show something a little more concrete than that, or particularized than that. And indefinite plans to return were not enough to show an actual or imminent injury. And as I mentioned, there was also a problem with showing that judicial redress would be effective in this case, because the funding in question was actually only a small fraction of the total funding for these projects. So with both of these projects, there was also funding coming from the government of Egypt with the Aswan Dam and the government of Sri Lanka for the development project there. And so our government was chipping in, but there was reason to think that the projects would have continued even without our foreign aid. So they probably would have continued even if the plaintiffs had won in this case, and that really undermines the idea of the redressability that they need for standing. Also, the plaintiffs were not challenging the funding of these overseas projects directly, and this is something, even if you looked at this case kind of superficially in constitutional law, you should take another moment and think this through a little bit more, because this might help you in future cases where you have to decide about standing. So they were trying to stop the funding indirectly by asking the court to compel the Secretary of Interior to rule that this statute, the Endangered Species Act, applied to US activities in other countries. And so that then those agencies who were funding these projects would have to stop. So they weren't suing the agencies doing the projects, they were suing the secretary, who basically gets to decide whether the Endangered Species Act applies, and trying to force him to reverse his decision. Okay, so let's talk about where this leaves us in terms of the doctrine of standing to sue. Standing requires injury in fact, and that really has almost two prongs. The first prong is also two parts. It has to be concrete and particularized to these particular plaintiffs, not something that just applies to everyone. And it either has to be actual or imminent, like almost actual. And then we have to have causation, and the phrase that the Supreme Court likes to use all the time for causation is fairly traceable. So causation is not a precise science, right? And in a sense, we could take causation indefinitely back in time, right? To if something hadn't happened 1,000 years ago, if someone had never been born, then none of this would be happening. So we have to have it be kind of reasonable causation. And then redressability means that a favorable judicial decision would provide effective redress for the injury. Now, where does this come from? This idea of standing, just to review, the majority says that the requirement of standing is implied in the cases and controversies clause in Article 3 of the Constitution. So for this doctrine of standing, they're grounding it in an implied principle in the Constitution itself. That's an important point for administrative law students, because this is a little different than some of our other additional standing requirements that developed, like the zone of interest tests in administrative law, that are more of basically a matter of are considered prudential rules or judicial common law. But this part of standing comes from Article 3 in the Constitution. And keep in mind, standing is particularly difficult to show here because third parties, instead of the plaintiffs, were really the object of the government's action. So it's a little different if the government is doing something to you, right? Like you're the target of an enforcement action, or they're confiscating something from you, or taking away your license, or something like that. It's an adverse action directly to you. Well, obviously you're going to have standing, but here what was happening was we have a federal action, and they're giving money to another party, basically to these governments of other countries, to do these development projects, and you're trying to come in and intervene and say, hey, stop that. I want to preserve the elephants, or I want to preserve the crocodiles. And so that's always going to be a little difficult or a stretch to show standing in that type of case. And that concludes our lecture about Lujan versus the Defenders of Wildlife.